Well, folks, we got a filing by KZ petition for review into the Supreme Court of the State of Wisconsin versus Stephen Avery. Issues presented for review, table of contents, whether the court appeals imposition of pleading standard requiring Mr. Avery to prove on the face of his 97406 motion that each allegation would result in acquittal, confliction, and controlling opinions in the United States Supreme Court, the court, and other Wisconsin Court of Appeals decisions. 2. Whether suppressing, withholding a CD for 12 years containing forensic police report of allegedly impeaching and or exculpatory material requires an evidentiary hearing to determine if Brady violation has occurred. 3. Whether a state actor is destructive of contested evidence in violation of Wisconsin Statute 968205 is sufficient evidence of bad faith required an evidentiary hearing. Youngblood versus Arizona claim. Destruction of evidence violated defendant's right to due process of law. Criteria of granted review. Issue 1, ineffective assistance of counsel. Issue 2, Brady violations. Issue 3, destruction of bone fragments. Statement of facts in the case. Argument. Whether the Court of Appeals imposition of a pleading standard requiring Mr. Avery to prove the face of his 97406 motion that each allegation would result in an acquittal conflicts with controlling opinions of the state's Supreme Court. This court, otherwise Wisconsin Court of Appeals decision, standard review, whether suppressing, withholding the CD for 12 years, containing forensic, that's the same thing. Let's get to the meat. Alright. Issues presented for review. Whether the Court of Appeals imposition of pleading standard requiring Mr. Avery to prove face of his 976 motion that each allegation result in an acquittal, conflicts controlling opinions of the United States Supreme Court, of Wisconsin Appeals decisions. The trial court held no. The Court of Appeals held that the trial court did not err in denying post-conviction motion without evidentiary hearing on the matter. Whether suppressing and withholding a CD for 12 years containing a forensic police report of allegedly impeaching or exculpatory material requires evidentiary hearing to determine if Brady violation has occurred. The trial court said no. The Court of Appeals held the trial court did not err in denying the post-conviction motion with the evidentiary hearing on the matter. State's actors' destruction of contested evidence in violation of Wisconsin Statute 968205 is sufficient evidence of bad faith to require an evidentiary hearing on Youngblood versus Arizona claimed that destruction of evidence violated defendant's right to due process of law. Trial court said no. The Court of Appeals did not address Mr. Avery's Wisconsin 968205 claim. Criteria for granting review. The primary function of the Wisconsin Supreme Court is that of law defending the law and development. Mr. Avery's case preceded an avalanche of coverage of a worldwide stage. It has generated legal commentary that has been matched in the last 50 years. Law review articles, law school classes, case law, petitions at the White House, and millions of documentary viewers have grappled one fundamental question: did Mr. Avery receive a fair trial free of consultation violations? When Mr. Avery was indigent and unknown, the Wisconsin courts dismissed his 2013 post-conviction motion as lacking any merit, being based on unsubstantial claims, empty and without substance, wildly speculative, and contrary to Wisconsin's long-standing law procedures. Now that Mr. Avery has obtained post-conviction counsel and nationally renowned experts, the Court of Appeals has applied a greatly enhanced pleading standard to his 97406 motion and has failed to look at the cumulative effect of the ineffective assistance of counsel and Brady versus Maryland claims. Also, the Court of Appeals has made sufficient factual errors resulting in unresponsible application of facts and analysis of bullet and bone evidence, which, among errors, results in the erroneous exercise of discretion in affirming the Circuit Court's denial of an evidentiary hearing. Mr. Avery should not be held to a higher standard than other moments. The Court should apply the standards as he has so clearly articulated in the past cases and allow Mr. Avery to have evidentiary hearing on the merits of allegations of constitutional violations. If his conviction truly has integrity, it will withstand the scrutiny of any evidentiary hearing. Without such scrutiny, the question of integrity and fairness of Mr. Avery's trial hangs large dark cloud over the Wisconsin judicial system. The case presents special and important reasons justifying Supreme Court review. Issue 1. Ineffective assistance of counsel. The first issue concerns whether the Court of Appeals erroneously exercised discretion when it applied a standard contrary to the Court's decision in State v. Allen, 2004, and contrary to the Court's interpretation of Strickland in Washington by requiring Mr. Avery conclusively prove his pleading without evidentiary hearing that his allegations would have been acquitted him. The Court of Appeals found and analyzed the cumulative effort of trial counsel's errors. The Court should reveal the misapplication of the Strickland standard and ineffective assistance of counsel claim pursuant to Wisconsin statute. Issue 2. The Brady issue concerns Court of Appeals finding the defense counsel was a burden diligence to replicate from raw data the state's exact findings. Contrary to the Court's decision, State v. Wersky, and Supreme Court jurisprudence, this issue also concerns whether Wersky compels the Court to find that the failure to disclose a police report allegedly containing favorable forensic evidence for the defense violates Brady, even if the defense could have hired an expert to do this on its own analysis. The issue further concerns whether the Court of Appeals erred by failing to consider the cumulative effect of errors assessing Mr. Avery's claim in violation of Kyle's Whitley. The Court should grant review based on the Court of Appeals decision and its conflict with the Court decision in Supreme Court Kyle's. Issue 3. Destruction of bone fragments. The issue concerns whether the state actor's destruction of contested evidence in violation of Wisconsin Statute 96A-205 is sufficient evidence of the bad faith to require evidentiary hearing on defendant's Youngblood v. Arizona. Claim the destruction of evidence violated his right to due process of law. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide and felony possession of a firearm. He was found not guilty of mutilation of the corpse. He appealed the Court of Appeals, affirmed in 2009. He filed a 97402 motion requesting a new trial. On January 25, 2010, after evidentiary hearing, Mr. Avery's motion was denied and appealed. The Court of Appeals affirmed. In 2013, Mr. Avery filed a pro se 97406 motion requesting a new trial, which was denied. On June 7, 2017, Mr. Avery filed a second 97406 motion. The motion was dismissed without evidentiary hearing. Mr. Avery filed a motion to vacate on October 23, 2017. He filed the motion for reconsideration. The Circuit Court denied this motion to vacate for reconsideration. On October 11, 2019, Mr. Avery appealed his filed motions to stay, remand concerning 2 additional claims. He raises his claims in the motions to the Circuit Court as supplemental post-conviction motions. The Circuit Court denied his motion and supplement. In April 2021, after new witnesses revealed exculpatory information, he filed a motion to the Court of Appeals to stay his appeal and remand. On July 28, 2021, the Court of Appeals issued a per curiam opinion upholding the Circuit Court's summary denial of Mr. Avery's claim raised in his 97406 motion and 2 supplemental motions, holding Avery's motions are insufficient on their face to entitle him to a hearing, or reserve Mr. Avery's ability to file a successive 9706 motion on his claims in his motion to reconsider, and 2 supplements his claim in most recent filing. With the exception of the unreasonable determination of the facts discussed here on pages 12 to 13, Avery will accept the facts as stated in the Court of Appeals opinions 2, 3, and 4. Whether the Court of Appeals' imposition of the pleading standard requiring Mr. Avery to prove on the face of his 97406 motion that each allegation would result in an acquittal conflicts with controlling opinions in the Supreme Court, this Court, and other Wisconsin Court of Appeals decisions. The Court reviews the Circuit Court's discretionary decisions under the differential and erroneous exercise of discretion standard. Whether a defendant was denied effective assistance of counsel is a mixed question of fact and law, impossible standard to meet. The Court of Appeals procedurally barred many of Mr. Avery's ineffective assistance allegations, concluding that Mr. Avery could have raised them in 2013, pro se post-conviction petition. The only sufficient reason for the Court of Appeals to accept Mr. Avery's failing to raise 7 of his ineffective assistance claims previously was that the unique circumstances existed when the pro se defendant unable to perform or pay for an investigation, but later gains resources to uncover new material facts and develop alternative theories of the crime. Finding their reason to be sufficient, the Court of Appeals praised out Stephen Mr. Avery's forensic expert opinions and reviewed each opinion as if it was a separate claim of its own. The Court of Appeals inexplicitly concluded Mr. Avery could have conducted experiments in his prison cell and 250 miles from the Avery salvage yard. Mr. Avery had no more ability to conduct simple experiments than he did to hire national renowned experts. All the allegations in the second motion should have been included in the court's reasoning, if not a bar. The court should address the issue based on the large amount of indigent prisoners, including Mr. Avery, whose diligent efforts to access resources are thwarted. The fact that the later an attorney will willing to devote hours of their time and resources because of their belief in the client's innocence should not be held against a prisoner when they later discover support of the ineffective assistance claim. Further, by parsing each Mr. Avery's forensic expert opinions into separate claims and analyzing each individual opinion as if there was a motion in their own, the Court of Appeals misapplied the standard for evidentiary hearing and failed to consider the cumulative effect of all Mr. Avery's forensic opinions. Among allegations and supporting materials, facts should be considered as one ineffective assistance of counsel claim, not transferred into individual ineffective assistance claims. The court should determine whether the Court of Appeals misapplied the legal standard of what moment must allege in the evidentiary hearing and unreasonably determined facts and misstated facts in the record in denying review. The circuit court must hold a hearing when the defendant has made a legally sufficient post-conviction motion and the discretion of the grant to deny evidentiary hearing even when the post-conviction motion is legally insufficient. It alleges sufficient facts to demonstrate that the trial counsel performance fell below an object standard of reasonableness when it alleged the counsel was ineffective, failing to hire experts, failing to investigate and impeach Bobby Dassey, the state's primary witness, failing to establish third-party suspects, failing in numerous other ways, including similar failures for prior post-conviction failure. Wisconsin cases that have found ineffective assistance for failure to hire experts. Rendon, ineffective, failing to hire a pathologist to refute the state's expert. The Court of Appeals erroneously applied Wathrell versus State. Hindsight is better than foresight approach to be Monday morning quarterbacking. Failure to consult with experts was not trial strategy. It was complete abdication of trial counsel's duty to at least attempt to reboot the most damaging forensic evidence in the case. Failure to obtain DNA analysis was not a strategic decision when defense counsel knew that the root tissue of hair specimens could be subject to DNA testing and did not pursue such testing. Failure to investigate thoroughly resulted in inaction and a reasoned strategic judgment. Current post-conviction counsel has demonstrated, among other things, that the blood in the RAV4 did not come from the EDTA tube, as trial counsel claimed, nor did it come from Mr. Avery's actively bleeding finger, as the state claimed. In Mr. Avery's motion, his new experts collectively rebuke the state's theory about each piece of forensic evidence. Mr. Avery sufficiently pled that the counsel was ineffective, and Allen, this court provided numerous examples of the motions not sufficiently pled, stating there is a clear theme running through these and other similar cases. In all these cases, the motion presented the material facts was repelled and bare bones allegations and was only based on the motivant own subject opinion. Mr. Avery's motion stands in stark contrast. With the Court of Appeals paid lip service on the court's Allen requirements, it failed to apply Allen criteria in Mr. Avery's claim instead of erroneously applied ultimate burden of prevailing on the post-conviction motion as Mr. Avery and received an evidentiary hearing. It improperly weighed the evidence Mr. Avery knew experts would have used to reboot the state's case in a circuit court if asked them. With the rule that Mr. Avery had an evidentiary hearing and failed, the court unreasonably determined facts pertaining to the school, blood, bullet, and bones would have been prevented if it had transcript to view the evidentiary hearing. A court of appeals is certainly not qualified to act as an expert in scientific evidence. Mr. Avery would have welcomed the opportunity to have the experts' opinions rigorously cross-examined by the state. Their ability to withstand adversarial challenge would have demonstrated the value of their findings to the jury. In finding that an order of movement granted evidentiary hearing, Mr. Avery's experts must prove Avery's defense unequivocally. The Court of Appeals imposed a burden contrary to the court's holding in Allen. It admitted that Mr. Avery's conclusions tend to support Avery's general theory that he was framed, and their presentation may have been useful at trial, but required that each expert reboot the state's entire case. After parsing Mr. Avery's forensic evidence into separate claims, the Court of Appeals improperly imposed a burden of demonstrating that each individual piece of evidence would result in acquittal, and even required Mr. Avery to show that the blood-staining experiments, each on their own, would have achieved acquittal, as well as required Mr. Avery's expert finding in the trace material of Halbach's subkey, the DNA quantity of the subkey in the hood latch, FL, bullet, the bones in Avery's burn pit would have each resulted in acquittal. Sorry. Where was that now? Lost my place. The court required Mr. Avery's finding the ultimate legal conclusion Mr. Avery was framed, which is ironic considering that the trial court did not require each piece of state's forensic evidence itself proved guilty beyond reasonable doubt. The jury presented with the cumulative effect of all of the forensic evidence. Moreover, the Court of Appeals misapplied the burden established in Strickland and Washington, included that Avery cannot meet his burden by misrepresenting the expert's result as demonstrating that he was framed, absent additional facts and arguments. We assume that such measured support for Avery's frame-up theory would have led to an acquittal. The Court of Appeals effectively imposed a standard completely contrary to the precedent of the law and ordered Mr. Avery to have an evidentiary hearing. He would have had to prove ineffectiveness of the face of his motion with the opportunity to cross-examine trial counsel. This is not a proper standard before even after evidentiary hearing. Strickland prejudice is established that if a reasonable probability at least one juror would have made a different decision. Well, yeah, why do you think they made up that bullshit excuse to excuse the one juror? Reasonable probability under standard probability is sufficient to undermine confidence in the outcome. The defendant is not required to show the counsel's deficient conduct more likely than an altered outcome of the case. The focus of the inquiry is not outcome of the trial, but rather the reliability of the proceedings. Rather than accepting Mr. Avery's fact as true, the Court of Appeals disputed facts and presented its own inaccurate version of the state's theory, in rejecting Mr. Avery's showing of the trial counsel's ineffectiveness. The Court of Appeals grossly misinterpreted the state's forensic evidence. The state's most important evidence for the Halbach's cause of death was a result of 1 to 2 gunshots to her head, and the bullets FL and FX used to shoot her were found in Mr. Avery's garage. Halbach's DNA was only found on FL, the Court of Appeals claimed, but the state did not argue that the specific bullet entered Halbach's skull or killed her. This is demonstrably false, because the state's expert testimony of the DNA in FL was a result of FL going through Halbach's brain. The Court of Appeals made another rigorous error when they found that there's nothing to suggest that the shots fired in Halbach's skull were the only shots fired at her, and every bullet fired at her contained skull fragments there were. After all, 11 casings and only 2 bullets were found in the garage. It failed to recognize that the 11 spent shell casings in Avery's case were never forensically linked to FL or FK or any bullet in the case. Dr. Eisenberg testified that there is no evidence of other gunshot wounds to the bones from other parts of Halbach's body. Sorry. Well, the court blatantly misstatement of the facts about the cause of the death of Halbach undermines the integrity of the opinion. When a lower court analysis begins to weigh the evidence in mistakes and uncontradicted facts, moment or asserts are not taken as true, and the need for an evidentiary hearing is apparent. A Court of Appeals failed to consider cumulative effect of trial counsel's numerous unreasonable errors. Without a true cumulative effect analysis, a lower court should not be permitted to conclusively deem the moment cannot demonstrate a reasonable probability of a different outcome. Citing Strickland, if the test is satisfied, relief is required, so supplemental abstract inquiry into the fairness proceedings are permissible. Addressing this issue, the court must consider a totality of the circumstances and must assess cumulative effect of all errors and not merely review the effect of each in isolation. The state convicted Mr. Avery on cumulative effect of forensic evidence. The Circuit Court of Appeals allowed the state to benefit from a cumulative effect of largely circumstantial evidence according to the impact of the proof the third party planted. Even one item of inculpatory evidence might have one jury's verdict. Whether suppressing and withholding a CD for 12 years containing a forensic police report of allegedly impeaching or expository materials requires an evidentiary hearing to determine if the Brady violation has occurred. In light of the court's holding, the United States Supreme Court jurisprudence, court should address whether the defendant's counsel failure to replicate the forensic evaluation relieves the state of its Brady obligation to disclose exculpatory and impeaching forensic findings. 2. Whether the states conduct consistent suppression. And 3. Whether the Court of Appeals erred in failing to consider the cumulative effect of errors in violation of Kyle's. The court should determine whether the denial of an evidentiary hearing was due to the lower court's misapplication of the law governing Brady. The court determines whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. This is a question of law review due. If the motion raises sufficient facts, the circuit court must hold an evidentiary hearing. If the motion presents only conclusory allegations, or if the record conclusively demonstrates that a defendant is not entitled to relief, the circuit court has discretion to grant or deny a hearing. Veely CD discovered 12 years after Mr. Avery's trial. Mr. Avery alleged the following facts on April 21st, 2006. Special Agent Tom Fassbender of the Department of Criminal Investigation and an investigator seized a computer from Dassey's residence. The state's forensics expert, Detective Veely from the Grand Chute Police Department, side note, conducted the forensic examination of the computer. The state administrator of the defense examination was Brendan Dassey's hard drive. On May 10, 2006, Veely completed a final investigation report based on his analysis of the computer and the crime scene facts, which included 2,632 unique word search results and 14,099 refined pornographic images, 1,625 of which had been deleted. Veely reporter received the Veely CD for the first time from the state. The Veely CD revealed the state's forensic analysis is based on the use of the computer by the state's primary witness, trial counsel's potential Denny suspect, Bobby Dassey. Bobby, and not Brendan Dassey. The Veely CD creates a timeline impeaching Bobby's testimony that he was sleeping immediately before Time Halbach murdered, and evident that the Court of Appeals was either unfamiliar with the record, discarded it entirely, it stated that it was skeptical that the Veely report impeaches Bobby's testimony about sleeping, and accused current post-conviction counsel of misstating that Bobby was home alone on October 31st during the time his computer searches were conducted. However, the Court of Appeals did not consider the fact that Bobby himself testified that he was the only person home 6:30 a.m. to 2:30 p.m. that day, relevant time prior to the searches. The Veely CD contains thousands of images, violent pornography, and word searches revealing propensity of sexual violence by Bobby. Because there is no possible way the current or prior counsel could have guessed the specific search terms and results which Veely obtained, Mr. Avery deprived of material information he could have used and established a direct link between the specific evidentiary terms related to the Halbach murder. Beauty and the test of the trial counsel would have included such information in their Denny motion if they had been timely disclosed. The evidence could have established motive for a trial counsel Denny motion, which trial court found was missing element. The court should have addressed whether the burden of the defense to replicate state forensic findings and which have been substantially withheld from them. Brady placed an affirmative duty in the prosecution to disclose exculpatory materials, evidence to the defense. Supreme Court expanded the holding on Brady. Returning the prosecutors have affirmative duty to disclose exculpatory evidence, the court rejected previous interpretations of Brady, finding that exclusive possession and control, reasonable diligence, and intolerable burden limitations distort original Brady analysis and purpose behind prosecutorial obligations, executed Brady. The court especially rejected an imposition of reasonable diligence standard on trial defense on counsel, stating, "The court has never analyzed the Brady claim through the lens of reasonable diligence, and we decline to adopt the requirement now due to the lack of grounding of the Brady in the Supreme Court precedents." In 2019, the court articulated an diligence requirement the defense contributed to the Brady in the Supreme Court precedent, but in addressing Mr. Avery's Brady claim on suppression of the VLCD, both lower courts agreed that the trial counsel failed to exercise diligence. The Court of Appeals imposed a burden on the defense to generate its own report analysis of raw computer data. However, given the pertinent consideration should be whether the material of which prosecution had possession, not disclosed to the defense, has evidentiary value, not whether the defense could have sought it itself. Rule of this declaring prosecutor may hide. Defendants must seek is not tenable in a system constitutionally bound to accord defendants due process. The weakness of the Court of Appeals analysis demonstrated on the exclusive reliance of Southern District of New York in opposing the controlling persuasive authority. The Court of Appeals applied upon McGinnis for the proposition that Brady not apply the secondary complication analysis of such. McGinnis has nothing to do with secondary complications of pertains to the knowledge the defendant would have about whether he took bribes. This would be comparable to Mr. Avery claiming that the knowledge that he had about whether or not he committed the murder of Halbach could ever be Brady material. The defense prevented from making meaningful use of the raw data because of its untimely disclosure. The prosecutor misled the trial counsel in three significant ways. 1. All the disks were disclosed. 2. That the computer was Brennan's. And 3. The analysis of the data was now not evidentiary value. The prosecution's lie about whether whose computer it was certainly affected trial counsel's decision not to evaluate it. When police or prosecutors conceal significant exculpatory and impeaching material in the state's possession, it is ordinarily incumbent the state to set the record straight. The state finally did set the record straight 12 years later in 2018. It was not until Mr. Avery could have realized the evidentiary value. The lower court should have barred from imposing any type of reasonable diligence burden on the defense counsel, especially in the light of prosecutors' dishonest conduct. Prosecutors' unwarranted concealment should attract the judicial This court, following Supreme Court jurisdiction or jurisprudence, defines suppression as non-disclosure or withholding of evidence from the defense. Following Supreme Court reasoning, the court retaliated, and that the prudent prosecutor will resolve doubtful questions in favor of disclosure. Finding that even a prosecutor's good faith and relevance to the inquiry, the issue whether Veely's final investigation report, although based on raw data disclosed to trial counsel, constitutes evidence suppression. It is undisputed that the Veely CD withheld from the prior counsels until April 17, 2018 was suppressed for 4,360 days after its creation. There is no possible way prior to April 17, 2018, current or prior counsel could have guessed Veely's specific search terms and their results, which were on the CD. Without an evidentiary hearing, Mr. Avery denied the opportunity to correct the circuit court's factual error that the CD and 70 DVDs were identical, although the Court of Appeals recognized that the CD contained different information than the 7 DVDs. It reached the same conclusion in an equally misguided way. It found that the VLCD does not contain any additional information that was in the 7 DVDs. But, conversely, it deemed the material of the VLCD not evidence. The VLCD does not suppress evidence, but merely investigative summary of evidence. The Court of Appeals ignored Mr. Avery's allegations in the post-conviction motion, but properly weighed the evidence. It gave more weight to the state's forensic investigator, Feely's affidavit that Mr. Avery's allegations and supporting material, including the affidavit of Mr. Avery's expert who reviewed the VLCD and 7 DVDs and found the CD contained unique information in determining the facts that the Court of Appeals improperly took on the role of circuit court, effectively failing to address whether the circuit court erroneously denied Mr. Avery of an evidentiary hearing because he had pled sufficient facts to the post-conviction petition, which is a pertinent question. As with any other civil pleading in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Even if the court disclaimed its belief evidence offered by a moment, the court must hold a hearing before credentially determinations. Only after hearing is a court charged with determining the issues, making findings or fact, conclusion of law. The Court of Appeals erred in rejecting Mr. Avery's argument that he should have access to information derived from Beasley's unique word searches, pornographic images, refined relevancy, and the like, because incorrectly deemed the report as secondary compilation of analysis of such. The Villi report is not a secondary compilation of analysis, it's a primary analysis of the raw computer data and crime scene facts. The Court of Appeals did not weigh in the fact that the state misrepresented its writing. The defense there was nothing more to evidentiary value anywhere within the date extracted from the computer, and permanently ignored the state's forensic investigator generated a report of Bobby's, not Brendan's, such history terms of bondage, gun, stab, handcuff, rav, throat, bullet, and fire. Unreasonably determined that the state's represented a stipulation projection of the merely off-the-cuff description of disclosed evidence, no reasonable trial counsel would consider the state's written remarks merely casual. The state's misrepresentation was in anything but off-the-cuff, since it was explicitly written in the prosecutor's prepared stipulation. A legally sufficient document, Mr. Avery trial counsel provided an affidavit considering the state's non-disclosure of the CD, which the Court of Appeals also failed to consider. Ignoring this affidavit, the Court of Appeals overlooked the state's misrepresentation of whose computer was analyzed. Only Bobby had access to the computer during the day on the weekdays when the violent pornography search was conducted, and on the day of Hallbach's murder, so the state's misrepresentations were material. The prosecution misled the defense into believing that there was, in fact, nothing of evidentiary value on it even to seek. The lower court erroneously imposed additional burden in defense counsel investigating potential state misrepresentations. Informant status results in the prosecution's misrepresentations and omissions, and the inmate was entitled to credit the prosecution's statements. The court should clarify for the lower courts that Brady encompasses the suppression of forensic report, such as much as any other form of evidence containing facts, impeaching, or exculpatory. The Court of Appeals misapplied the law concerning the materially cumulative effect of evidence. The Court of Appeals admitted that the VLCD might be relevant to showing Bobby Dassey's motive in the future. However, it failed to address the cumulative impact of the CD and that additional evidence undermined the state's case. Without a true cumulative effect analysis, a lower court should not be permitted to conclusively deem that a moment cannot demonstrate a reasonable probability of a different outcome. The court must consider the totality of the circumstances and thus not merely review the effect of each isolation. The Court of Appeals failed to consider the cumulative effect with rejecting Mr. Avery's claims, namely his new discovered evidence, ineffective assistance to counsel claims, and his 5 other Brady claims. By failing to consider a cumulative effect of the errors, the Court of Appeals erroneously applied standard contrary to Avery. Even the Strickland requiring that the VLCD itself to be acquitted Mr. Avery. This is contrary to well-settled law. To prevail the Brady claim, Weary need to show that more likely than not would have been acquitted and a new evidence be admitted. Petitioner shows cause when the reason for the failure to develop facts in a state court proceeding with the state suppression of relevant evidence. Coincident with the third Brady component, prejudice within the compass of the cause of prejudice requirements exists with the supposed evidence and is material of Brady violation. Knowing its theory was weak, the state relied upon Bobby's statement to establish that Halbach never left the Avery property on October 31st, 2005. Mr. Avery has shown the suppressed evidence was favorable and impeaching, and also shown cause, because he has shown the reason for his failure to develop facts in the state court proceedings was due to the state's suppression of material evidence. Mr. Avery suffered prejudice because the material would have impeached the state's key witness. Bobby would have revealed the motive and would have qualified the third party to any suspect. Consider the cumulative effect of evidence in light of the efforts. Combined, the reasonable probability would have, like Bobby Dassey. If you didn't do this, talk to KZ's investigators. That's the only way this is going to go away. But you hiding ain't going to help anything. Y'all, the whole family needs to come together if they really want justice for Stephen Brennan and Teresa. That's my thought. But I will continue onward. Whether a state actor is destructive consistent evidence of violation of Wisconsin state is sufficient evidence of bad faith to require a hearing of defendant's Youngblood versus Arizona claimed that destructive evidence violated his right to due process of law. In 2011, state released bone fragments discovered in the Manitowoc gravel pit, placed into evidence as part of the investigation of Halbach's murder. They were also discovered around 2:10 p.m. on November 9th, the same day they arrested Stephen Avery. Which, yeah, I mean, I'm just going to read this document. I'm going to get lost talking about the case. State released bone fragments discovered in the Manitowoc gravel pit, investigated Halbach's murder, Halbach's family. It did so without giving any notice to Mr. Avery. The state removed evidence, tags signaling the locations from which the bones were discovered, and completed the gravel pit bones with bones from two other areas. In every burn pit, Dassey burn area, and all the areas in the gravel pit were Manitowoc County property. Shortly after post-conviction counsel moved to remand the additional significant testing, discovered the state in 2011 returned bones to the Halbach family, effectively destroying them without first giving notice to Mr. Avery's counsel. Mr. Avery then moved to the Court of Appeals to stay his appeal and remand for circuit court to consider his claims relating to the destruction of evidence pursuant. The Court of Appeals distracted the circuit court by permitting Mr. Avery to pursue a supplemental post-conviction motion and conduct any necessary proceedings. The circuit court denied Mr. Avery's motion without hearing. The Court of Appeals affirmed the circuit court's decision. This was an error because the decision contravenes Wisconsin law on preservation of evidence because there is no remedy for a violation of relevant statute. The court should address whether the state's violation of the state preservation of certain evidence satisfies the bad faith requirement of Youngblood. In turn, warrants an evidentiary hearing for Mr. Avery. In 2001, Wisconsin recognized the importance of preservation of certain evidence for purposes of post-conviction relief. And you know why that is? There was a case here, this lady was murdered on the Summerfest grounds. She was at a bar with her friends. They left her at the bar. She was seen talking to a guy with a cowboy hat on. But anyways, they found her murdered underneath the home bridge. They went to go retest the evidence. This happened in Milwaukee, and for some messed up reason, Mike Glazer's responsible for that too. They disposed of evidence to make room in their evidence lockers, and they got rid of DNA evidence that could have probably solved the case. And that's just one case. Who knows? This isn't, I don't know. I'm going to go on. Wisconsin recognized the importance of preserving certain evidence for post-conviction relief, enhancing several evidence preservation statutes. Notably, Nowhere in Wisconsin did the Wisconsin legislation provide a remedy for this violation. Article 1, Section 9. The Constitution requires statute to provide a remedy for a violation, and such court has been declared. Wisconsin courts have authority to fashion a remedy-less statutes. This court should find that showing the violation of Wisconsin Statute 986205 is sufficient showing of bad faith required by Youngblood for an evidentiary hearing. In Youngblood, the Supreme Court adopted a test requiring the defendant to show the evidence merely potentially useful to the case, and that the police acted in bad faith when destroying it. Wisconsin statute creates their presumptions that all evidence covered by the statute and collected in the course of the criminal investigation is material because the materially is potentially useful. The first Youngblood prong, and since the evidence presented statute effectively codifies good faith, every violation therefore indicates bad faith. Wisconsin has signaled that the enactment of Wisconsin 968205 and through the Wisconsin Court of Appeals opinion Parker, Wisconsin evidence preservation doctrine applies to the post-conviction context. The circuit court found that because no DNA testing was performed on the material returned to the family, that conclusively identified material as belonging to a human being or being specifically individual. The evidence is questioned cannot come within a plain meaning of the statute. The plain language of the statute, however, does not require that the biological evidence belonging to the victim by DNA test to provide it to the victim, such as reading the state statute, defeats the purpose of allowing destruction of evidence without the notice of the defendant, Mr. Avery case. The state held bones at the Hall box, and Mr. Avery sought to conduct further DNA testing. He learned the bones had been destroyed without notice to him. A previously undisclosed police report documents that those bones were held out to the victim's family, being the victim's bones. Yes, for those of you that may be new to this case, when they supplied Kathleen Zellner with the CASO summary report, they just so happened to not include a couple pages, which she's talking about right here. The Court of Appeals earnestly focused only on an estimate of the state's forensic anthropologist, confirming that analysis of the suspect human bone fragment labeled 8675, which was found in the Montauk gravel pit, and only bones from the gravel pit introduced to the trial. The court ignored entirely Dr. Eisner's reports, which described numerous other human bones in the gravel pit, which explains why Ken Kratz only wanted to spend 20 seconds on the bones in a gravel pit, because he knew it would destroy his fucking case. Therefore, erroneously concluded that the bones given to the Hallbach family were simply interment in origin. Mr. Avery alleged sufficient facts showing the violation of statute in the second way, that the state's effective destruction of gravel pit bones was a destruction of evidence that may reasonably be used to incriminate and exculpate the persons of the offense. The state went great lengths to confine the murder of the Avery property into one person because it made the case against Mr. Avery much easier. It is here where the exculpatory value of bone fragment evidence lies. Mr. Avery was tried and convicted to the theory. He also killed and burned Hallbach in his burn pit. After burning Hallbach in his burn pit, most inexplicably have moved her bones over to the Ashley burn barrel, and then suspected her bones from the Manitowoc gravel pit. Not Avery property, simply, really not evidence, precisely because they could not be identified through DNA testing human Hallbachs. Now this makes me think, when Stephen Avery is given an interview on the 4th, and Bobby Dasher takes on his four-wheeler, where is he going? Precisely because of that. Okay. The Court of Appeals overlooked that Mr. Avery is found not guilty of mutilating a corpse. Its reason, the apparent thrust of Avery's claim, is that if Hallbach bones were found in a gravel pit, then she was killed by someone else. As Avery never explains why he himself would have been able to dispose of Hallbach's remains in the gravel pit, this line of reasoning wholly speculative. The very obvious explanation that Mr. Avery would have been able to burn Hallbach in his burn pit, then transport her remains to the gravel pit for purpose of court. Hypothetically, Mr. Avery was acquitted of burning Hallbach's body in his burn pit, or burning or mutilating Hallbach's body at all. The gross misunderstanding of the facts caused the Court of Appeals to start from a premise of not supported by the record that Mr. Avery is reasonable for taking the bones of the gravel pit. His jury decided that just the opposite. It is undisputed the Halbach's body was mutilated after her death. The potential inculpation of another person in mutilated Halbach's body, for which Mr. Avery was acquitted, is strong. Undisputed fact that Mr. Avery was acquitted for mutilating Halbach's body by burning it in the burn pit signals that bones were planted on Mr. Avery's burn pit. If the bones were planted on Mr. Avery's burn pit, it is potentially expulsory to him. Mr. Avery were able to test the gravel pit bone fragments, and the testing yielded DNA and other person. Mr. Avery would be able to provide suspected mutilation in Halbach. Side note, there's also cut marks on all the bones. So if the bones have the same cut marks in the gravel pit that they do in other locations, it's the same person, same bones. But she needs to be able to do the testing. The state admitted that the bones in the case were removed by the killer, and cannot be said that the state would appreciate the potential for the killer's DNA to be on those items. Evidence to claim the killer must have touched and moved. The bone fragments. The state admitted the bones in this case. I got so much going through my head right now. I'm sorry. Cannot be stated with the appreciation of the potential of the killer. This evidence claimed the killer must touch and moved. The bone fragments of Dassey burn barrel. Appeals in court of the state. The gravel pit pelvic bone taken under evidence 8675 had similar curve marks. I was just talking about that, suggesting that they came from the same source. Underwent the same destruction of mutilation. World leader in curve marks analysis could have conducted analysis and determined whether the remainder of the gravel pit bones displayed similar cut marks. Gravel pit, pelvic bone, bones in the Dassey burn barrel. Testing these bone fragments, DNA profile of Halbach, DNA profile of the real killer, could have provided exculpatory evidence. Mr. Avery, the state's destruction of evidence, has deprived Mr. Avery of the opportunity to do so. The state was well aware of Mr. Avery's theory that he was framed for the murder committed by another person. Almost every part of Mr. Avery's defense at both trial and post-conviction stages has been assert that Halbach and her vehicle left the property. Halbach was killed off the property, and remains and personal effects were then planted on Avery property. The state knew the potentially expulsory value of the bones, and that testing them may reasonably be used to incriminate, exploitate a person of an offense. Because the state violated and has sufficiently demonstrated the bad faith requirements of Youngblood, alternatively, the court should grant new trial to Mr. Avery in the interest of justice. Mr. Avery has demonstrated that the real controversy of the trial was not fully tried. Therefore, it probably there is a miscarriage of justice. Mr. Avery's jury was not presented with the suppressed evidence revealed in his substantially discovered Brady claims. Mr. Avery knew experts' findings, which completely refute the state's theory, create a reasonable doubt in Mr. Avery's guilt. Conclusion. Petitioner Stephen Avery's case raises three critical issues on which the court guidance is needed. Mr. Avery represents the court with the opportunity to correct the lower court's misinterpretation of the pleading standard to obtain an evidentiary hearing. Mr. Avery claims. Second, Mr. Avery presents the court with the opportunity to decide whether Mr. Avery sufficiently led Brady claims, warranting an evidentiary hearing and an alternative new trial. Third, Mr. Avery presents the court with the opportunity to fashion a remedy, state gathered destruction evidence violation, decide whether the state, if sufficient evidence, bad faith, to award evidentiary hearing Youngblood claim, an alternative grant, new trial and assistance of justice. Petitioner Stephen Avery respectfully asked the court to grant him a leave, appeal, and issue raised and signed Kathleen's on there this date. I hear we're certified. Well, I gotta read all that. Yeah. So, I don't know. What are y'all thoughts? Let me scroll through the chat and see if. So I guess we won't be getting that little whatever the fuck they called it. Can't think right now. The state was supposed to minimize their response to KZ's filing tomorrow. But yeah, like I said, this is like a chess game. You must think before you move and always be 3 steps ahead. I'm gonna try to gather a few people. I don't know. I'll see y'all when I see y'all. Y'all have a great day.